Today I'm going to talk about mastering negotiation, both from the perspective of a lawyer and also leadership. And of course, begs the question, what is negotiation? Well, we of course negotiate in many aspects of our life. We might negotiate with our children to brush their teeth and eat their vegetables. And we certainly negotiate with our workmates in terms of the work that they need to do, even in a power structure. But I've landed on a slightly different definition here, much more legal for those in the legal industry. Negotiation is when two or more parties with competing interests come together to form an agreement. And it's not necessarily the best agreement, but it's an agreement that they can live with. And you noticed I focused on the word interest as opposed to position. And if you look at the negotiation theory, there's obviously a key difference made between position, what someone will articulate they want or may not want, and their interest, which is what underlies it. And that's, of course, borne out by the work of Fisher and Shapiro, etc. Let's first talk about two forms of important negotiations, particularly in terms of the role of lawyers. So the first circle is trust-based negotiation. Now, that's where we want to be most of the time with our teammates, with our stakeholders, with our clients. We want to be in the zone of trust. So that's one circle. That can be contrasted with more adversarial style of negotiation. That's when there's litigants. We're acting for a party. In litigation, with some exceptions, there are winners and losers. It's about incremental concessions. So I want to cover off on those two. One, trust. Two, a more adversarial context of winners and losers. Let's first look at the question of trust in negotiations, remembering this is the mainstay. This is where we want to be in most of our interactions. So it begs the question, how do we promote trust in our negotiation and in our relationships? The first tip is listen first and judge later. And I think that's really important because really negotiation is very much a process of discovery and finding out information. So that's critical. The second key skill, particularly in trust-based negotiation, is the game of rapport. You need to be able to make connections with people to understand them and understand their perspectives. I think something that's overlooked is the importance of setting boundaries that are consistently maintained because that builds trust. So I'll give you an example. As a lawyer, if you're dealing with a client, you're constantly at times, depending on who you're dealing with and their level of sophistication, you may be talking a lot about what can and can't be achieved in the legal system or in a piece of litigation or in a work that they're doing. And that's about setting boundaries, and that really does embed trust, even though it mightn't be necessarily what a client always wants to hear, but it's important because it embeds trust. It's important in building trust that you communicate at people's level. And we all know that when we're dealing with a wide variety of people. Very important as well in mediation. And finally, and I think this really goes to the heart of leadership in professional services and trust, and that is make promises that you keep. I'm a big believer in life that people are much more interested in, and look much more closely at what you do rather than what you say. So if you're trying to create a culture of service, you go back to people as a leader when you say you would, you finalise advices when you say you would, you do what you say you're going to do, you keep your promises. That embeds trust. Remember, trust is a long-term process. The old Dutch proverb that I like goes something along the lines of trust comes on foot but leaves on horseback. What I'm trying to convey there is it takes time to build, but like a reputation, it can be quite quickly lost. So that's the game of trust in rapport-based communication and in trust-based negotiation. But then, and this is for lawyers in particular, they play a different game in litigation, which is more results-driven. It's about the blunt instrument that is sometimes the law that can be winning and losing and getting results. So the question is, how do we negotiate, and do we negotiate differently in those types of environments? And the answer is yes, we do negotiate differently. Although, of course, it needs to be said that the second environment, an adversarial environment, is not a trust-free zone. There are at least ethical constraints that apply, and that's something that'll be the subject of a separate podcast. And now we're going to cover off on a more adversarial skill set required. So when you're, as a lawyer, acting for a litigant, let's face it, litigation can be blunt, it can be about winners and losers, and it's often the game of incremental concessions and bargaining. Now, I've thought as a mediator, surely there must be a better way than this incrementalism and this bargaining. But I haven't landed on one yet. It actually works over time. So you've got to be able to play that game effectively. And of course, there are ethical constraints within it. Sure, there's allowed to be a level of puffery, but it should go no higher than the evidence at its best, or no lower than the low watermark of the evidence. It's got to be attached to the evidence for it to be ethical. And when you're in this style of communication, you're often more guarded, but still over time rapport develops. And that's why largely in Queensland we've been so successful with the ADR movement, because there's been already a high level of professionalism and collegiality baked into the Queensland profession. So that's about negotiating in the context of a more adversarial, position-based field. The next point is, how do you leverage the three variables that are involved in every negotiation? Now, you might think one of the variables is money, but it's actually not. And this comes from a book from Herb Cohen entitled, You Can Negotiate Anything. So the three variables at play in any negotiation are power, time, and information. And let's break that down a bit. Now, power is an important dynamic that's always present in negotiation, but it's actually a lot more nuanced and complex at times than you would think. So, for example, in the injury work that I do, you might have an injured person and an insurance company. Now, sure, there's power that rests with the insurance business on the basis that they hold a checkbook, they sometimes might have a whole portfolio, etc. So there's power in that. But there's also a lot of power in the story of the injured person that's often forgotten. There may even be a power of adverse publicity. There's a power of the fact that they may have nothing to lose. There's the power of the fact that they're aggrieved and may be really emotionally invested in the litigation. So power is quite complex and nuanced and needs to be thought about in any negotiation. The second variable is time. Time is really an important variable. If you have the time to take, and if you can say no, you've got a lot more control in any negotiation. And I'm a big believer in litigation that the party who best manages the time frame, who's more proactive, generally gets a better result. So time is an important variable, whether it's on your side or not. And we use that variable as a mediator, of course, because, we keep people in the room and we use time to try to get people to do a deal. And the third variable, which is really important, is information. And often as lawyers, we think about that in terms of evidence more than information. But obviously it is, as I said, negotiation. Even in litigation, it should be a process of discovery. It's not just about what you want to say, but it's more about finding out what is the case that you're meeting. And that's about really asking lots of questions and being curious about information. Because remember, as a lawyer, that your job is to advise your client on risk in the process of a mediation or negotiation, but all the way up to a court if it goes to judgment. And the best way you can advise your client on risk is to not only be alive to your strengths, but to really drill down onto the strengths of the case that you're required to meet. And that's about acquiring information or evidence. I really do encourage people in negotiations to treat it as a process of discovery as opposed to just a process of stating their client's position. Also, for those involved in litigation, the question then becomes, for lawyers, how do you leverage the money? What do you do? Well, sorry, no shortcuts here. There's no substitute for really good preparation. You really need to build the aspects of the claim where you think the loss is, and in injury litigation, that's invariably economic loss and care in more catastrophic injury claims. So there's no substitute for the hard work involved in leveraging the money. There's a number of other strategies that you can adopt. One strategy that's commonly adopted is to stay high and to get people to meet you. That's using a concept called framing, where you're telling the other party this is a high value claim. That can be effective, but often you find as a mediator you get to a point where you have to ask what their realistic expectations are, and your job as a mediator is to try to get to the nuts of that anyway. But that's a strategy that's used to varying degrees of success and can, depending on the circumstances, work. I think it's really important in any negotiation in the legal context to take control of your client effectively. And I think there's a tendency for lawyers to think that they're in charge of the show, they run the process. And I think you'll find a new generation of lawyers is very much using their clients, I think it's very effective. For example, if you're acting for an injured plaintiff and you think they're really a good person that's well presented, get them to do the talk and get them involved in the process. I think that can be quite powerful. We are, of course, creatures of emotion, and that can make a difference. And it also means that they are seen and heard and have their day, and that can be quite important as well. So that's another lever that you can use. It's really important to think about the fact that in any negotiation, even if you think you're dealing about money or compromise, there are still emotions that are invariably at play. I'm going to cite some emotions now, and I get this from a book, See Beyond Reason, Using Emotion as You Negotiate, a book by Daniel Shapiro and Roger Fisher. And they talk about 5 emotions that are present in all negotiations. First of all, appreciation. Even if you have different views, people need to be seen and heard. So appreciating their position is really important. The second emotion that's present is affiliation. So the notion that, for example, that you see that a bit in the legal community, like we're both doing a job, we're both arguing our case, but we're both part of a profession. That's the process of affiliation, and that's an important emotion that comes to play. Another emotion that they talk about is respecting autonomy. That's critical, and that goes to the heart of a mediator's role. It's your call ultimately, you're well advised, or it's the insurer's call. You really respect autonomy, people to make their own choices. You acknowledge the roles of people. Role is really important. Sometimes I think as a mediator, we might be inadvertently, and I'm really conscious of this, excluding some people that we don't want to. We might be talking too much to the lawyer or not enough to the client or not enough to a claims person. So it's really important to acknowledge people's roles so that they feel included in the process as best you can, even though you have to be across a lot of relationships often. And then, of course, you acknowledge status, which is done as well because people are quite status driven. That's about negotiation in both the context of trust, teams, and negotiation in the context of an adversarial litigation-based skill set. Thank you for tuning in to the Resolution Room.